Introduce our next speaker.
Thank you very much. Thank you to both speakers as well. It was a wonderful presentation. So our next presentation for the World Federalist Conference will be by Roberto Zamora on the ICJ cases between Costa Rica and Nicaragua. So Roberto Zamora is a dedicated Costa Rican human and civil rights lawyer, renowned for his unwavering commitment to justice, human rights, and social advocacy. He has a distinguished career spanning several decades. Roberto, he's played an instrumental role in championing the rights of individuals and marginalized communities in Costa Rica and beyond. His legal expertise has been instrumental in challenging systemic injustices and advocating for meaningful change in his country. Roberto's dedication to civil and human rights has not only led to landmark legal victories, but also inspired a new generation of activists and lawyers to follow in his footsteps. So without further ado, I will pass it on to you, Roberto.
Hello, everybody. Thanks to Alex and Gary and the World Federalist movement for the opportunity and the invitation. I will talk on several litigation cases where Costa Rica has been involved.
Roberto?
So,
I'm having some trouble hearing you. Could you just make sure you're speaking, I think, straight towards the mic might help. It's a little bit tinny.
Okay, I will shut the door. Yeah, maybe better now.
I think it's better.
Yes, I will share the presentation in a minute. So, just to introduce, I will be talking about cases on domestic level and at international level. And Costa Rica has been both like good and bad. However, one of the presentation is to highlight the importance of the existence of international law mechanisms. So let's see how it goes. Now it's a lot of material and it's only 20 minutes for the presentation. So I hope everybody had a coffee or a power drink because it's going to be rushy. So let's try to keep this, and I will share the presentation in this section. All right. So So there is a few things that are important to mention. One is the legal framework of Costa Rica, because it's very important in terms that it's very unique. And then we will deal with these 4 cases that, as you can see, have been introduced international domestic level. So first thing that is to be said is that Costa Rica is a non-militarized democracy since 1948. It has the most extreme case of a monist legal system. A monist legal system is where you don't make any difference between international law and domestic law. So you can go to a domestic court and directly invoke international law provisions. This is very linked to the fact that we abolished the military in 1948 and the coming of the UN and the International Court of Justice in 1945. So with the end of the war the Second Great War and the coming of the UN came the scope for a new international system that would be based in peaceful settlement of disputes and the rule of law. And Costa Rica decided to make basically a leap of faith, very extreme, and decided to abolish the army. Costa Rica accepted the compulsory jurisdiction without any reservations in the ICJ. And Costa Rica has actually, of course, with some mishaps in history, pretty much tried to abide by international law. As a result, we are a country with a very stable democracy, very stable international relationships. We don't have enemies. We have into place the cheapest defense policy in the world because we don't need a military to defend ourselves because we don't have enemies. So this is part of the framework that Costa Rica has and makes it very unique. Also, international law, human rights instruments have a supra-constitutional hierarchy, which is also a very important thing to do. So a becoming or ratification of a international human rights instrument can bring to, for instance, the derogation of a constitutional rule. Costa Rica is also a neutral country since 1983, and here, yes, there's a little problem. I thought I had corrected this. This is not a case of Costa Rica versus Iraq. This is actually me versus Costa Rica regarding the decision of the Costa Rican government to support the coalition of the willing that invaded Iraq. Back in the day, I was a law student. I was 22 years old, and since in Costa Rica, you don't need a lawyer to claim for constitutional or fundamental rights. So I decided to file a case for the Constitutional Chamber of the Supreme Court. In the allegation that Costa Rica supporting the coalition of the willing was against international law, it was against the UN Charter, it was against the right to peace, and court ruled in my favor and order, well, not in my favor, because it's actually, I mean, it was for Costa Rica, let's say.
Roberto, I just want to let you know people are having some trouble hearing you, so just make sure you're speaking towards the mic when possible. I'm not sure where the mic is on your laptop.
Okay, I normally don't have this issue, and I'm normally very loud, but I'll talk louder. So the court found that indeed the support of the Costa Rican government had violated the Constitution under the obligation to abide by international law. And this because the decision to support the coalition was against the UN Charter, since the Security Council had never authorized the invasion of Iraq. Also, the court found that this support violated the obligation of neutrality and principle of peace as understood by the Supreme Court. Okay, so here. Okay, so okay, thank you. Then it seems there's a little bit of mix up. Well, anyway, the second page we have to revise is the invasion of Portillo's Island. This is a case brought before the International Court of Justice by Costa Rica against Nicaragua. The San Juan River is suitable for navigation. and it connects to the Nicaragua lake that it's only separated to the Pacific Ocean by only 20 kilometers of land. So making a canal there, it's actually a very good idea. It hasn't been done for political issues throughout the history of Nicaragua. In recent years, Nicaragua decided to start trying to build a canal, and they faced the problem that there, as you see in the map, in Punta Castilla, you can go to the next slide. That's perfect, in fact. So in the yellow area, which belongs to Costa Rica, and that's the court determined, makes that turn, and where you see Punta Castilla is exactly where is the mouth and the inland waters connect to the ocean. Now, because of particular positioning, the mouth would create sediments that would make it impossible for the ships to get into the canal. So Nicaragua found that if they could straighten the course of the river along that red line, there would be current enough to eliminate the sediment and let the ships in. So Nicaragua decided that it was going to cut that, and then the land on the left would belong to them. And Nicaragua invaded that area and started dragging. As you can see, the damage was quite significant. The court did find that Nicaragua had violated Costa Rica territorial sovereignty, and that it had violated several international environmental law principles, like the cautionary principle, the no harm principle, and finally, Nicaragua paid reparations, was ordered to abandon Costa Rican territory, and Costa Rica, I believe, has finished repairing the damage. At least the tax area has been filled and trees have been replanted, so that should be right in a few years. We can go to the next case, which is a case that was submitted simultaneously by Nicaragua against Costa Rica, because since Nicaragua had invaded Costa Rica, the government issued an emergency decree which had the intention to build the road to have access to the area, because that area that Nicaragua invaded, as you can see, is jungle. There is no signs of civilization for 30 kilometers around, and like no roads, no nothing. The only way to get there is by the river, and the river is Nicaraguan. Costa Rica only has navigational rights on the river, but it's under Nicaragua sovereignty because President Cleveland decided it that way. San Juan River is one of the only two rivers in the world that are bordered but not shared jurisdiction. So after the emergency decree, Costa Rica went on to build this road that was a mess on our side of the river, and court did find Costa Rica had violated international environmental law, not because the road caused any harm on Nicaragua's side, because it didn't, but because Costa Rica didn't conduct the environmental impact assessments. And that was a violation of procedure and a violation of the precautionary principle. So Costa Rica, I mean, since the road was already there and there was no damage to Costa Rica, the court just declared the violation, but no orders were issued. And Costa Rica abandoned the road, so it's just God's will at the moment. I mean, it's a mess. We can move on. Yeah, we have a mix-up of cases, but it doesn't matter. The fourth case that we have is the nuclear weapons case. That it follows on the case of the Iraqi of the position of the Costa Rican government regarding the invasion of Iraq that we just saw. So what happened in this case was that in 2006, during his second term, President Arias decided that it would be a fantastic idea for a peaceful, demilitarized, and neutral country to start building nuclear reactors, nuclear fuel, and to allow the extraction of thorium and uranium, which we have in the country. The purposes for the uses of these reactors, fuel, and uranium allowed military uses. So I went again and filed the case against the decree before the Constitutional Chamber of the Supreme Court, saying that the authorization for corporations to start doing those activities would be in violation of international law, particularly obligations that Costa Rica has acquired under the Non-Proliferation Treaty, the Tableau Treaty. And I further argued that there was the domestic customary rule of international effect on Costa Rica regarding the right to peace. That Costa Rica had built through strict state practice and iuris a unilateral domestic obligation that happens to have international effect. And the court accepted my thesis this time and declared effectively went beyond. I mean, the court did somehow a very, very good work here, because the court found a bunch of violations. I mean, obviously, it found the violations to the nuclear obligations. It did a very, very interesting exercise in accepting my thesis that states can build unilateral customary obligations of international law. In this case, the right is that Costa Rica recognized of a constitutional dimension. The court were further to find that pretty much in the lines of the advisory opinion of the ITJ, that the use of nuclear weapons is against environmental law, the right to health, and the right to life, that it violates the principle of discrimination in attacks, and that nuclear weapons would be against the right to a healthy environment that we who have constitutionally recognized in Costa Rica through the Constitution and by the Inter-American Convention on Human Rights. So the court found that I did not argue, but I'm very, very happy that the court went into that. And finally, that I don't know if I already said this, that it would be a violation on the right peace. Furthermore, the court went on to determined that the Constitution implicitly included a full and absolute ban on any activity that has as a purpose its use in a war. Whether it is designing, stockpiling parts, entire products, transport, import, export, like any activity was pricing that the Supreme Court used in that ruling. So this case was very important. It was the first. I mean, the Iraq war case was the first time in history that a court told the government that you cannot support a military action. And the nuclear weapons case was the first time in history that a Supreme Court recognized as a derogation from the constitutional principles an absolute ban on nuclear weapons, and for the particular case of Costa Rica, military, other military goods. I don't know how. Yeah, I think we're just on time. I don't think if there is any slide left. Yes. Okay. I will try to go as quick as possible with this case. This is a case also domestic. I did not participate in this case. It was handled by an environmentalist group. So Costa Rica decided to allow a Canadian corporation to extract coal from that area that you see there with the red star. Now, the area, as most of the northern part of Costa Rica, is just jungle and forest. So it happens that in that particular area grows a very particular tree that produces a very particular fruit that is the only food that a very particular bird eats. And the government didn't give a nickel about that. So in a very, very, very dirty move, on a Friday at 4:30, just before everything was to be closed, President Arias and the Ministry of Environment signed a decree authorizing the corporation to start its activities. By Monday morning, the environmentalists had made it to get the administrative court to have a cautionary measure halting the activities of the corporation. The results, I don't know if we have an image, like results were terrible. So all that devastation plus another area that is pretty much the same size happened in just the span of 2 days, which were also Saturday and Sunday. So they had everything ready. It was so dirty. It was typical Oscar areas. So anyway, finally, after many years and after appeals and after the case reaching the Supreme Court confirmed that the authorization for the project was against the right to a healthy environment and a series of environmental law principles that should have applied. No harm, precautionary principles. There was a lack of impartial and procedural obligations, like the impartial environmental assessment. The court also found the violation of several international legal instruments that Costa Rica has signed regarding environment, like the Convention on Biological Diversity, and several principles included in the Rio Declaration. It has to be noted that there was one specific species of bird that its existence depended, the bird is endemic to the region. It depends on the existence of that tree. So, as you can see, Costa Rica has been a very good and bad example of environmental law compliance, but in the good way, it has allowed room for legal mechanisms to start showing signs of advance. And when it comes to climate change, we already know what's going to happen. The countries know what's going to happen. Allow me 2 minutes for closing. And it's newcomers know it so much that if you read their defense papers, they rather invest in security and weapons to prevent migration, private migration, than tackle and prevent the effects of climate change. So it's either courts or the streets. In Costa Rica, in this regard, by showing how law can be a mechanism, I think it's very important. Whether in the cases where it has failed in its initial action, but has then complied after the court ruling, or when it has had to act, like in the case of the Nicaragua's invasion. And with that, I think.
All right. Thank you so much for your presentation, Roberto. Let me add myself to the spotlight. Yes, thank you for elaborating on Costa Rica's unique relationship to international law, its interesting legal context. I now invite our participants to put their questions in the chat. So I think the first question I want to ask is, through this sort of relationship to international law, we've seen, not just environmental protection, but also, turning around and no longer supporting the US 2003 invasion of Iraq. Multiple facets of international law have been upheld. Other than the fact that Costa Rica doesn't have a military, what are there avenues for other countries to enshrine international law in their existing system? Actually, I'll let you answer that, but I will go to Rebecca Shute after to ask a question.
Right. Unfortunately, international law is very ill equipped in many aspects, and one of them derives from the issue that its application is still based pretty much on state consent, right? And that state consent does and can be translated into domestic affairs. So, for instance, Costa Rica not only had consented to pretty much every single international treaty that is there, like blind, but Costa Rica also consented to decide that it makes no sense accepting obligations for the state, but are only for the state outwards. So, in that regard, also, as somebody who works in international law, I really don't understand the dualist system. It does make no sense to me. So, what we need for states to allow the introduction of international law in domestic legislation is they wanting to do so. And the courts in some countries have stretched a little bit certain principles to integrate slowly certain international legal principles, like the Paris Agreement. The very recent Rugenda case is very interesting in that regard, as the court in the Netherlands determined that the Netherlands had to raise its fair share to at least 25% of reduction of emissions, because the Paris Agreement is binding. That obligation for maximum ambition is binding. So, I mean, in the case here, which is very recent, is fundamental. So, I stress on the importance that the courts can play here if the legislative are, as normally happens, influenced by lobbies and corruption and, the industrial complex and all these people that, for economic reasons, they'd rather suffer the effects of climate change than act on it.
Thank you for that response, Roberto. I'm going to spotlight Rebecca. Shoot. One moment.
And thank you so much, Erica. My apologies for violating protocol a little bit by asking my question in person, but it's mostly to see my friend Roberto, with whom we co-lead this project, Legal Alternatives to War. And I learn from you, Roberto, every day, and I'm inspired by you. I guess my question stems from something that we ruminate over quite a bit. I come from a jurisdiction in the United States at one end of the spectrum of martial perspective, pugilistic kind of bent, and you come from Costa Rica. And often we see, and tomorrow, I think in particular, this Congress will be joined by a lot of young people from diverse jurisdictions around the globe. And we often hear like Costa Rica is a unicorn. This is so unique that you have this Pacific notion baked into the Constitution, into your identity. What lessons can be extrapolated for those of us who do not hail from such jurisdictions, who do not hail from legal systems and orders that put peace first? From your experience as a young lawyer, as a law student who's gone through this process, that we can take forward in our journey for international peace and justice. So thank you, Roberto, and thank you, Erica, for the spotlight.
It's a very difficult question because it's very difficult what it means to live in peace, like without any relationship with the military, or like that didn't exist in my life until, like, I was older and I was aware that armies, I thought it was an issue of cartoon, but I never thought it was the real thing until I was like a little bit older. And this is something I say often, like, this is right. The only way you enjoy the right is by living in peace. And of course, this is not just the fact that we don't have a military or we don't have any association with that, but also when I grew up, we were an agrarian society living out of this crazy consumerist neoliberal world. And we didn't have much, but we didn't have wants. We had everything. We had education, we had a decent lifestyle, we could eat, we had a house, I could play in the coffee plantation nearby my house, and it's it makes part of your identity as a person, right? So there, to be honest, Costa Ricans don't really care much about many things, but when it comes to peace, they do care. And it does mean the impact it has on us as a society. Now, the thing that we can get from the Costa Rican example is that this is not a fairy tale. It's not.
Could you repeat that last part? Sorry, Roberto. It just cut out for me. If you have any other tabs open on your computer, you can close the presentation tab. It might help with your connection a little bit. Otherwise, it's just a little echoey. Sorry to interrupt your
speaker. So what we can get from the Costa Rican experience is that this is not a fairy tale. I mean, it's a real thing, like we do exist. Hello, Costa Rica, we are here, like, let us be seen. I mean, it is possible. I mean, it is possible, and we've been doing it for 70 years. So, there is the other the technical part of it. When Costa Rica decided to abolish the military, we also decided that we were going to divert the funds of the military into healthcare and education. And that's when the human rights development indexes of Costa Rica began to separate from those of the rest of Latin America. Costa Rica has one of the highest human development indexes in the region, as is and the average of most developed countries, in fact, by 0.86 or something, which is considered high. And we don't have the money that these rich countries have. So how do we do it? Well, we don't waste money in arms. I mean, we just don't waste money in arms. We don't make enemies. We understand national security in a completely different way. I mean, it's not harming to your teeth that you're safe. The other guy's gonna do the same because now he's afraid of you. And I mean, and that just shows how the whole war never ended. I mean, we are still in the same dynamic. So I sometimes say that Costa Rica is actually a very, very, very important country, not because it's my country, but because it represents where the highest bar is. And in that regard, it should be of the interest of the international community to keep an eye on Costa Rica so we never lose track. Because we cannot lose the higher bar, the highest bar. So I think that's what we can take from the Costa Rican experience. Rebecca, thanks for the question. I find it very interesting.
Thank you for your response, very thoughtful. I'm going to go to our next question is from Alan Ware. It came in the chat. Can you compare the experience in Costa Rica regarding the Costa Rican peace constitution and the experience of Japan with regard to Article 9 of their constitution?
Sure. The fundamental thing that makes the difference between both these constitutions, and for those who doesn't know, has Article 9 in its constitution that in principle, Japan shouldn't have an army, whether they call it or not self-defense forces, which is a redundancy because the purpose of an army is to defend the country as an act is illegal. So anyway, setting that aside, but Japan nonetheless has an army. So what happened was that, and Japan also has a lot of American military that also shouldn't have, according to the text of Article 9 that says that Japan shall not maintain any sea, land, or air forces without making any distinction of they are domestic or foreign. Nonetheless, Japan has both. So in 1950 something, Japan and the United States signed the security treaty known as TAPO. And this guy, Sunakawa, entered a military facility, was arrested, and then argued that the presence itself of the US military was illegal in Japan because TAPO was against Article 9 and the Constitution. And there, the Supreme Court wrongfully ruled that the Article 9 was to be interpreted that Japan wouldn't maintain land, sea, or air forces, but domestic, and that it didn't make any specific regulation about foreign military forces. And on those grounds, the Supreme Court of Japan in the Sunakawa case upheld the validity of ample, which, if you ask me, the position is absolutely wrong. Furthermore, the Japanese court also bought this stupid idea that you can rename the army as a self-defense force, as if by nature armies were self-defense forces. And under that very, 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 very stupid argument, Japan has managed to maintain both a domestic army and the U.S. Army there. So what we see is the difference is that Japan doesn't, at least as it regards the specific cases, like my case and the Sunakawa case, but Japan didn't show a functional judiciary, and Costa Rica did. And that's why it's also so important, again, the role of courts and the role of having a functional judiciary that will not be subject to political pressures or interests and will upheld law as it should.
Thank you for that response, Roberto. I want to ask you, I have a question. One of the cases had to do with a mining operation, a Canadian mining company operating a subsidiary in Costa Rica. This is standard practice for Canadian mining companies. Canada has one of the lowest tax rates for mining companies, so a lot of them are based in Canada, and they operate subsidiaries all over Latin America. Do you think this could be an avenue for other Latin American countries to seek justice through international institutions? And if so, you know, or maybe what are the barriers, if not?
Yes, and it's important also to note that since the Cruzitas case with Infinito Gold, this Canadian corporation, since the Cruzitas case, there have been several very important developments in international law. Many of these mining corporations do create what is called sacrifice zones, which are areas where, pardon my French, but life is here. Like the effects of the mining corporation and the pollution and so on undermine the living conditions in such a horrendous way that the lifespan of these people is dramatically reduced, and their life quality and every single right is affected. Right.
Roberto, I think people are having trouble with your question. It's just not picking up all of your words. You don't have a microphone or headphones with a mic on you. Sorry to break the question. Just give Roberto a moment here to try to correct the sound issues we've been having.
If this works better.
Much better, much better. Yeah.
Oh, okay. So, what was I saying?
The question was about other Latin American
Sacrifice
countries.
zones.
Yeah.
Yes. Sorry, sacrifice zones. So there is some advances in the proposal of understanding that sacrifice zones amount to inhuman degradement or even torture. And as such, they should be prohibited, which by default would have a massive impact on these projects because they cannot survive without the sacrifice zone, right? So I do believe there is also, at least in Latin America, and it's also important to link that in Europe and Latin America, there have been specific advances regarding procedural regulations and environmental rights, access to information, participation, and consent for certain specific groups through the Aarhus Convention and the Escazú Agreement, which are instruments that grant people rights of access to information, participation, and legal protection in environmental issues, which is fundamental. The Escazú Agreement furthermore adds a provision concerning the protection of environmental defenders. So there have been very significant advances that can be incorporated on top of like the Cruzitas case, for instance. But yeah, it's stepping stone. In fact, and beyond any doubt, is a stepping stone that can help in the progress of international law.
Perhaps there's even some room for the proposal for an international anti-corruption court, since you mentioned there was quite a bit of corruption involved, and that wouldn't be the first case I had heard where Canadian mining companies were trying to abuse countries where they felt that they could pay their way to do whatever they wanted.
Yeah, that happens a lot in the region. It's still an issue we are trying to deal with, and that's where the access to information, governance, and transparency play a significant role.
It begs the question of accountability, but not just for some of the Latin American countries that Canadian companies take advantage of, but for the Canadian companies that have their modus operandi. They know exactly where they can exploit these weak spots.
Yep.
This question comes from Alex McIsaac, our executive director. Thinking of countries that also don't have a military like Iceland, Andorra, are there strong cases of any other countries that have tried to follow Costa Rica's model for resolving international disputes?
Yes, there are plenty. I mean, because Costa Rica is not an isolated case. It might be maybe a extreme case of adherence to international law and peaceful settlement of dispute mechanisms. But no, if you check, for instance, the website of the ICJ is full of cases. The regional courts of human rights on very, very few occasions have also intervened there. I think with the African court in a case of the Democratic Republic of Congo against Uganda, in the Inter-American Court, there was one case of Ecuador against Colombia. But no, and then there is also a lot of countries go to other softer mechanisms like high offices, diplomacy, negotiations, conciliations. There is also arbitrations. So yeah, I mean I mean in the end the use of force come to very limited scenarios, right? In which countries, well, feel that they are beyond international law because there is no way to sanction them. And that's how we have seen the Americans, the Britons, the Russians invade at will, because in fact, the only way to stop them is through a world war. And we don't, well, I think we don't want that to happen. So yeah.
What about in domestic Supreme Court cases where international, these are a lot of international courts that we've mentioned cases, but within domestic Supreme Court citing international treaties that they've signed on to, is that something that there's a lot of precedent for?
It's coming more often, at least in the Inter-American as it comes to the human rights regime in the inter-American system, according to the court jurisprudence, as a matter of principle, domestic courts should apply the Inter-American Convention on Human Rights by default. I mean, domestic courts should apply conventionality control. So that is a door fully open, and actually there is a little bit of a push there to go through the door for states in order to apply international law. Now, in other jurisdictions, it's starting to happen. As I said, the Urgenda case, it's very, very important. And I think that environmental law, I have the hope that environmental law is going to bring a little bit to an end of the fragmentation among international law and between domestic and international law, because I mean, the environment is everything. Like we are in the environment, the environment is the planet itself, right? So, and whatever is in it. So the environment as an issue is transversal to everything. I mean, and there is no way you can detach currently any issue from the environment. It's there everywhere, like it's omnipresent. So no, there are advances there. I, as a lawyer, have many hopes that finally lawyers will do some good. You know, like we don't have the best reputation, but I hope that changes if we start like growing a consciousness as a, group.
Yeah.
So yeah, I mean, I'm a little bit of a rocket man, but I do have the hope that that lawyers will finally do something good and play our part when it's the most needed.
Thank you for that response. I'm going to go to a question from the chat. Let's see. This one comes from David Flores. Just reset it. He's interested in knowing your standpoint on the conflict-sensitive reportage of the dispute between Palestine and Israel, and any insights you may have there.
If you ask me, it's very concerning, because here is where the cookie crumbles. I mean, it's to me, it's the breaking point in international law. I mean, the occupation of any state in the 21st century, it's an aberration to me. The United Nations doesn't really want to acknowledge its fault on the issue. That partition, I mean, even if the partition should have happened, it should have happened under two states. What Israel is doing, under my opinion, it's in fact genocide. I believe that the developments since the issuing of the cautionary measures from the ICJ have only added enormous amount of evidence, the daily videos of what the soldiers are doing in the ground and their joy and happiness after every bombing, explosion, killing, or torturing of innocent civilians. They had already pushed them to Rafah, and there is no more south there. And if they move to Egypt, it's certain that they will not be allowed to come back, and Gaza will become a settlement. Rafah is, as of today, a concentration camp. Israel has violated every single obligation under international humanitarian law to provide for those displaced, among many other violations in international humanitarian law. So I hope, because the court allowed a month for Israel to report on compliance with the cautionary measures, and I'm eager to see that report happening, what South Africa will bring to the court with all the evidence that comes forward. And I do hope that the ICJ orders the Security Council to take measures to enforce the cautionary measures issued. And here is where we see, I mean, the future of the UN as we know it will depend on what the Security Council decides, if the ICJ refers enforcement to the Security Council. I believe that for the interest of the United States will have to yield and actually order Israel to stop. Not because they care of the Palestinians, because it's on the interest of the United States to not put themselves in a position where there is absolutely no defense for a genocide.
Thank you so much for your presentation, Roberto. We are closing the Q&A now, so I just want to say we appreciate your time, and to everyone who put questions in the chat, thank you for keeping the discussion so interesting. I'm going to turn it over to Alex.